Hi, welcome to Legal Tech Diaries. As you know, my videos are split into two parts. First, we discuss the legal side of the topic, and then we shift into legal tech side to see how it functions in modern legal practice. In today's video, we will continue the topic of capacity. We will discuss the three remained groups: mentally incapacitated persons, intoxicated persons, and companies. So let's start with mentally incapacitated persons. Who falls under this group? Under Section 2 of Mental Capacity Act 2005, a person lacks capacity if, due to impairment or disturbance of brain or mind, whether temporary or permanent, the person is unable to make decisions by themselves at the time the contract is formed. Let's discuss and understand the legal aspect of such a contracts. So, are they valid? The contracts are valid but voidable by the limited capacity, by the person who has a limited capacity. But this person should prove two things. First, he could not understand the nature of the contract. The second one, the other party was aware of impairment. So this works also not only for the mentally incapacitated, this proof, but also for intoxicated persons. This principle was established in the cases Imperial Loan versus Stone and Hard Corner. So let's now understand what, if it's enforceable, if the contract is enforceable, and when it is rectified. So it is such a contracts, again, with the limited capacity persons are enforceable. So rectification means that the contract is fixed or adjust, but the fixes and adjustments are only in a written contracts and refer to wording. For example, the wording in the contract was not right, and they are adjusting, so fixing only this part. And such a contracts are enforceable. So now we have reached the company's limit part, and the companies also face the limitations. That means that the companies should not go beyond their power, and they sometimes did not have such an authority to enter into the contract. So when they are going beyond the power, for example, in instance that is not written in the articles of association, and these contracts could not be valid with these persons. But in cases when the other party, and this is established in the cases, in the case Ashbury, a railway iron versus Ritchie, and also in the 39th section of the Company Act. But it is possible that such a contracts are still valid. This is when it is beyond the power. This is called ultra vile, and this means that they don't have the authority. The company has no authority to enter to such a contract. But if the other party was dealing with it in a good faith, that means that they have a belief that they are dealing with a, for example, director who has that authority. In these cases, the contracts are enforceable. So it's always difficult and sensible to control this the contracts with the limited capacity persons. But in a legal tech, it's possible to automate such steps to see before the contract turns legally binding if the one of the parties or both of the parties are have capacity. So, for example, the automated contract tools like DocuSign or Juro, they have built-in behavioral processes which detect the behavior of the mentally incapacitated and intoxicated persons. So they're detecting if they're typing, if the person who is trying to enter into the contract has a hesitation, other behavior, or is typing slowly, and such small games, so mini games or memory games, can be suggested to check that, and the results would show if the process should be stopped and be forwarded to a human review. And also for the companies, it is possible to make the automation so the association, the articles of association can be automatically checked, and the whole documents, the whole authorities have what has the company can be integrated in the platform, and it would be automatically checked and be prevented in the cases where the company has no authority to enter in such a contract. So that was all about the capacity groups, and thank you for watching. See you in the next episode.